All rise, the 75th District Court back in session. The Honorable Michael D. Carpenter presiding.
Thank you, everyone. Please be seated.
Little rusty.
Still me. Yeah, a little rusty. Before we let the jury in, I'm going to recall the case. Katrina, are we back on? Looks like we are. I think she's probably muted.
Yes, Your Honor.
On the case, the People State of Michigan versus Jawan Curry, file 20-1125 SM. Counsel, please identify yourselves for the record.
Thank you, Patrick Swinsky for the people.
Good afternoon, Your Honor. Brian Jean on behalf of the defendant.
Is there any issues we need to address before we bring the jury back in, Mr. Shawinski?
No, Your Honor.
Mr. Jean?
No, Your Honor.
All right, please rise for the jury. Thank you, everyone. Please be seated. Mr. Shawinski, your next witness or a piece of evidence.
Thank you. I'll call Officer Rob Hammond.
Line up here, please, officer. We'll have you sworn in. Raise your right hand.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Watch your step around the ramp.
All right, Officer, can you state your name for the record, please?
Robert Hager, Hager,
Okay, your occupation,
police officer,
and what agency do you work for?
City of Midland Police.
How much experience in law enforcement do you have?
21 years,
Okay. How long have you been at the Midland PD?
just over 6 years.
And I'm going to address the elephant in the room. You were yawning quite a bit. You worked last night, didn't you?
I did.
So you've not gone to sleep yet.
I have not.
Okay. Well, I appreciate you being here. Okay, so, I'm going to go back to August 19th, 2020. Were you on duty that day?
I was.
And I'm assuming it's not unusual for you to end up, not necessarily because you're injured, but at the Midland Hospital. Is that right?
That is correct.
You were there that night. Is that correct?
Yes, I was.
All right. And at some point, did you come in contact with a Katoria Crawford?
Yes, I did.
Okay. And what was the reason for that?
A nurse made me aware that an assault victim had just came into the ER for treatment and that she wished to make a report.
Okay. And then what did you do?
Made contact with Miss Crawford in her hospital room and took a statement from her.
Okay. Did you determine this was a domestic violence situation?
I did.
Okay. And she made a statement to you? Is that right?
She did, yes.
Okay. What did she say?
She advised me that she got home from work at approximately 8:45 p.m. When she got home, her ex-boyfriend was on the porch waiting for her. When she went to go up the stairs to her apartment, her ex-boyfriend asked that he wanted to talk with her. She said she didn't want to talk, went to walk past him. As she was walking up the stairs, he grabbed her by the hair and pulled her back down the stairs, which caused her to hit her head on the concrete.
Your Honor, I'm going to object at this point. Two things, one hearsay, and then second is non-responsive.
The objection.
Hearsay is admissible in this particular situation, Your Honor, because it is a domestic violence statement under the statute. We did provide the notice to the attorney, Your Honor.
Response regarding that, counsel?
I would await the court's ruling.
All right, I'm going to make the determination that the proper notice was given. The statute is clear. It will allow the statement to be made into the record. However, the second part of that objection, Mr. Jean, was
Non-responsive.
non-responsive.
Yeah.
So it's a more of a narrative as opposed to a question and answer. So I will sustain the objection for that. So ladies and gentlemen, the process when a person testifies is typically question and answer and not just one. It's very common and normal language for people just to continue talking. However, the rules require a question and answer type format. So that's the objection and why I'm ruling this way.
Thank you.
Yes.
first of all, where was she located when she made the statement to you?
In a hospital bed.
Okay. Was she laying in the bed at the time?
Yes.
And you asked her about an assault that occurred with her boyfriend, correct?
Correct.
All right. And what name did she give you at the time?
Jonathan Curry.
All right. So she stated her boyfriend who assaulted her was Jonathan Curry.
Correct.
All right. And what did she say happened when she approached the door?
Mr. Curry asked her to talk.
All right. And what was her response to him?
That she didn't want to talk and walked past him.
Okay. She tried to continue inside the door. That was her statement to you?
Yes.
All right. And what did she say Mr. Curry did at that point?
That he followed her up the stairs and grabbed her by the hair and pulled her back down the stairs.
All right. And did she make any statement about what happened next?
Yes.
What happened next?
Once she was on the ground, she said that he kicked her numerous times in the head and ribs.
Okay. And then did she indicate what happened after that?
Yes.
Okay. And what happened?
She advised Mr. Curry grabbed her around the neck with both hands, stood her up, and then took her back up the stairs towards the door of the apartment.
Okay. And at this point, did she indicate that the assault ceased, or how did it go from there?
She advised when they got to the door of the apartment, his phone rang. He let go of her, and she ran into the house, shut the door, and locked it.
Okay. And what did she indicate that she did after that?
After that,
Yes. Did she? I'm sorry. Let me rephrase the question.
Okay.
It's a little complex. She continued to give you a statement regarding what happened after she was able to get behind the door, correct?
yes.
Okay. What did she tell you?
I'm sorry, I don't recall off the top of my head.
Sure. When she made the statement to you, you were wearing your body camera, correct?
I was, yes.
Okay. It's pretty. You're not wearing it right now, are you?
I am not.
Okay. Where would it be positioned on your body so that she can show the jury?
It sits right on the edge of my pocket,
Okay.
down the center of my torso.
So right kind of next to your pocket, right kind of where you have a button down shirt somewhere in the middle of your shirt.
Yes.
And just briefly for the jury, can you describe how those work?
So it's a camera, the video camera that's mounted to my chest. When I interview someone, anytime I'm out of the car talking with anyone, there's a big round button in the middle of it. I just push that and it turns it on. And so it captures everything that's said between me and the person, or what the person says back to me, along with some video. Now the video isn't always at the proper level to get everything, but audio is always there.
And I think you testified you were wearing your body camera that day.
Yes, I was.
And did your body camera capture your conversation with Ms. Crawford?
Yes, it did.
Okay. Can I approach, Your Honor?
You may.
Showing you what's labeled People's Exhibit 5. I'm sorry, Plaintiff's Exhibit 5. It's a CD. Do you recognize that?
I do.
And that right there, what is that?
That's my signature and badge number.
Okay. And I had showed you this previously to indicate what was on the CD, correct?
Yes,
And what was on it
my body cam footage
from that night?
from August 19th,
Okay.
2020.
At this point, Your Honor, I would seek to admit it and also play it to the jury.
Any objection or voir dire?
No, Your Honor.
All right, the exhibit 5 will be admitted, and I believe, Mr. Schwinsky, when you play that, it should be on the big screen, correct?
Yeah, and I'll clarify, Your Honor, I spoke with Mr. Jean about this. We're going to play it up to the 10-minute 30 mark.
And you both agreed the 10-minute 30 mark is appropriate, relevant, and it would be admissible under the court rules.
That's correct.
That's correct, Your Honor.
Okay, so the jury will not see the entire footage, but because of the court rules, we're showing you up till the 10-minute 30.
And just so the court's aware,
this video, if it needs to be reheard, can only be done here on this machine, in this setting, in the courtroom. It cannot be taken back to the jury room. There are other pieces of evidence, pictures, you might be able to do that, but because there's a limited time, up till 10:30, that both attorneys believe that we're within the court rules, we need to make sure that that's monitored. So if there is a situation to where it needs to be heard again, or if there's a request for that, it must be here in the courtroom with everyone present. Mr. Schwinsky, you may continue.
Thank you. Okay. I'm going to it's already done. Sorry. And I will put this with the exhibits in just a moment, Your Honor.
All right.
Okay, Mr. Haggard, obviously you just viewed the video. After she gave you the statement, did you proceed to take any pictures?
I did.
Okay. May I approach, Your Honor?
You may.
All right, I'm showing you plaintiff's exhibit 1 and 2, which have already been admitted. Do you recognize those?
I do.
Did you take those photographs?
I did.
And those are of Ms. Crawford's injuries, correct?
Correct.
All right. I'm going to present to you now plaintiff's exhibit 3. Do you recognize that photo?
I do.
And that's, what is that?
It's a photo of a bruise
Located somewhere on Ms.
somewhere on Miss Crawford.
Okay. And you took that the night in question, correct?
Correct.
Is that a fair and accurate representation of what you saw?
Yes.
At this point, I move to admit people's 3, Your Honor.
Would your objection?
No.
It'll be admitted.
I'll publish as well. Okay. Finally, Mr. Haggard, after you finished up at the hospital, what did you do?
I went to 710 East Grove Street.
Okay. What'd you do there?
Tried to make contact with anybody that may have seen what happened or heard what happened.
Were you able to do that?
There was nobody there that witnessed anything. I did make contact with a person.
You did make contact with someone?
I did.
Okay. That was, I believe we've already talked about him, that Mr. Hughes, is that right?
Correct.
Did you take a statement from him?
I did.
And was he able to offer anything of any value to you?
He was not. He said he didn't see or hear anything.
And did you take a photograph of the house? Thank you.
I did.
Can I approach again, Your Honor?
You may.
Thank you. All right, I'm showing you what's marked as plaintiff's exhibit 4. Do you recognize that?
I do.
What is it?
There's a picture of the steps and front door to 710 East Grove Street.
Okay. And is that a fair and accurate representation of the way it looked that evening?
Yes.
All right. I move for the admission of people's 4 as well.
Or your objection?
No, Your Honor.
Exhibit 4 will be admitted.
And I will publish.
All right.
As well. Okay. Now, Mr. Hager, at some point, or Officer Hager, I apologize. At some point during the statement, obviously, Ms. Crawford indicated that the suspect was a Jonathan Curry. Is that right?
Correct.
And you made some inquiries to try to determine where Mr. Curry was or who he was. Is that right?
Yes.
And as a result of those inquiries, you determined that it was actually, his name was Jawan Curry. Is that right?
Correct.
All right. What'd you do after that?
I attempted to locate Mr. Curry to get a statement from him. Was not able to find him.
All right, nothing further. Thank you.
Cross-examination?
Thank you, Your Honor. Officer, good afternoon. How are you?
Good.
Good.
Thank you.
You were able to listen to the testimony today. Is that correct?
Yes.
You would agree with me that testimony today was quite a bit different than what you were told in this video.
Yes.
Okay. Would you agree with me that on the video, it appears that Ms. Crawford is intoxicated, I guess?
I wouldn't
Or
necessarily agree with that.
perhaps to put it another way, it appeared that she was under the influence of something.
I don't know if she was or not.
Okay. You heard her testify today. She was on Dilaudid. Is that correct?
At some point when she was in the hospital, she was on Dilaudid, yes.
Do you have training regarding spotting persons who are intoxicated, correct?
Absolutely.
Spotting people who are under the influence, correct?
Sure.
That would be for drugs and alcohol, correct?
Yes.
All right. Would you agree with me that some of those cues that you would be looking for, you would have seen in Ms. Crawford that evening?
Those could have been attributed to other things also,
Of course.
but some of those cues were there, yes.
Point being, video, it appears that her speech is slowed and she appears tired and lethargic, yes?
Which could also be caused by a head injury, but yes, you are correct.
Well, there wasn't any diagnosis to your knowledge of that, correct?
Correct.
Okay. How is it that you obtained the name Jawan Curry?
Based on previous history between the two of them in our computer system.
Okay, so if you could explain that, there's a couple different things that you can use, one of them being caliber, correct?
Correct.
Could you explain what that is?
It is our records management system that we use for typing reports, keeping records of everything we do, basically.
Okay, and it's true that during your search of that system, you ran into Ms. Crawford's name along with the last name of Curry, correct?
Correct.
And that is how you obtained the name Jawan Curry.
Yes.
And you didn't find any person by the name of Jonathan Curry either in the lean system or in the caliber system, correct?
Correct.
And I don't know if you explained this. What is the lean system?
It's the Law Enforcement Information Network. It's a state and national system. If I were to stop you driving down the road, that's what we use to check driving histories and criminal histories and stuff like that.
So when you ran the name Jonathan Curry, nothing came up, correct?
Correct.
All right. Did you confirm with Ms. Crawford the name Jawan Curry?
Did I confirm?
Yes, sir.
I recontacted her after I had interviewed her and asked her if the person's name could have been Jawan instead of Jonathan. Yes.
Okay.
I think that's what you're asking, right?
Yes, that is what
Okay.
I'm asking. And what did she tell you?
She said that he always went by Jonathan.
Okay.
That was the only name she knew him by.
Did you believe her to be lying to you?
Not at the time. No.
You also attempted to find witnesses that may have seen the incident.
Yes,
And to do that, you went door to door.
I did.
And did you make contact with anyone?
A couple of apartments.
And all of those contacts resulted in no further information. Is that correct?
That is correct.
To put it kind of more bluntly, the people that you spoke with said, I didn't see anything.
That's correct.
All right. Now, we also spoke earlier during Ms. Crawford's testimony, and then you were asked by Mr. Schwinski regarding a Mr. Hughes. That person, the first name is, I think it's Jakaya, I think that was what it was. And that is what Ms. Crawford today described as her cousin. Is that correct?
Yes.
Jakaya had indicated to you that he had witnessed nothing and heard nothing, correct?
That's what he told me, yes.
Did you ask if he had been home that evening?
I don't recall.
Okay. You did hear the testimony earlier of Ms. Crawford that they typically were working around the same times?
Yes.
Essentially nothing at that time caused you to believe that Jakaya was not home at the time, right?
Yeah, I have nothing one way or the other.
Point being is you had asked him if he had seen anything, and it's not as though he volunteered information like, I just got home or something along those lines.
Not that I recall.
Okay. You have been in law enforcement for 21 years or just with Midland for 21 years?
21 years in law enforcement, a little over 6 in Midland.
All right. You've done multiple police reports, correct?
Yes.
You've made some determinations in your career as to what you see with things like injuries or statuses of vehicles, like if a vehicle is potentially totaled, right?
Yes.
Okay. You actually put that there's sections in your police report to put those sorts of things, correct?
I'm sorry.
So you have different sections in your police report, like incident location, incident offenses, the officers involved, and things like of that nature. Is that correct?
Correct.
And in fact, in your police report, there's a section regarding injuries, correct?
Could be.
Okay. May I first witness?
Are you planning on helping refresh his memory
I
or
am.
what purpose? All right.
Well, I guess I can just ask, because perhaps he knows. In your police report, you indicated that there were apparent minor injuries. Is that correct? Would it help? So we'll do it this way.
Yes. So, yes, it probably does say that. I don't normally see the printed copy of the report.
Sure.
We have drop-down boxes in our RMS system.
Yeah.
That is probably what I clicked on. Yes.
Yeah, it'll like automatically generate. It'll give you the option of,
Yes.
serious injury,
I don't
things
remember.
like that.
I don't remember what the
So
drop-downs are, but
just so we're clear, would it help to refresh your recollection as to what you selected or what you put in that box if you were to see your report?
yes, I believe that that's probably what is there. If you want to, it would help refresh my memory.
You may
Yes, sir.
approach the witness.
It's
Yes.
right there. Already circled. Okay.
Yes.
Okay.
That is what I clicked.
To your knowledge, you did not gather any information at any point that Ms. Crawford required any sort of surgery or other medical intervention. Is that correct?
I did not. No.
And you actually never did interview Mr. Curry, did you?
I did not.
Actually, in fact, were you ever even able to locate him at that time?
I was not.
Okay. You also indicated that you took a picture of the front door. Did you find that the latch and or any of the hinges were broken?
I did not.
I guess.
I honestly, I didn't look close enough at it to determine that.
That was my next question. Thank you. You noted at some point that Ms. Crawford did indicate to you that the door had come off its hinges. Did you not?
I don't think I noted it anywhere other than it was said in the interview.
Right. Okay. Was it just something that you didn't feel was terribly important in terms of the case itself, or?
It was just something I overlooked when I was typing my report.
Okay. All right. Officer, thank you. I don't have anything further.
Any redirect?
Just two things quickly. When you were talking with Ms. Crawford at the hospital, did you obviously you deal with people who are drunk and intoxicated all the time? Is that correct?
That is correct.
You have a pretty good idea what that looks like.
I do.
Sure. when you talked to Ms. Crawford, did you feel like she was of sound mind?
She seemed to be, yes.
And so you were confident that the statement she was giving you wasn't being influenced by some type of lack of sobriety or something to that effect?
I didn't believe so, no.
So you had confidence that what she was telling you was what she experienced?
Yes.
And then secondly, you were in the hospital with her. It looked like there were quite a few nurses. She was clearly being treated for something. Is that fair?
Yes.
Okay. Was there, I don't know if you saw, was there an IV being run or?
They did run an IV.
Okay. Was the IV already there by the time?
I don't recall
Okay.
if the IV had been.
Sure. Because it sounded like she was still complaining of some pain at that point.
She was.
So perhaps she hadn't been given that's allowed at that point.
Objection calls for speculation.
Sure. That's fair. That's fair.
So the answer will not be given. If it was, it'd be stricken.
Yeah, that's fair. But clearly she was undergoing medical treatment at the time.
Yes.
Okay. Nothing further. Thank you.
Are there any questions from the jurors? If so, please raise your hand. No hands are raised. May the officer go back to the prosecution table.
Yes, Your Honor. Thank you.
Any objection?
None, Your Honor.
All right.
Thank you, sir.
Any other witnesses?
No other witnesses, Your Honor.
Are there any other exhibits? I think you've admitted exhibits 1, 2, 3, 4, and 5.
Nope, that's all the exhibits. I'll return this to the bench as well, Your Honor.
Okay. I don't know if I have them. Yeah, they're right here. So at this point in time, do the people rest?
Yes, Your Honor.
All right.
And well, I'll wait for Mr. Dean. Go ahead.
Mr. Jean, do you need to have any legal motions that you need to place on the record?
Probably, yeah.
Okay. So what we're going to do is temporarily have jury go to the jury room. So I address a legal issue that I need to decide, and then we will have you brought right back in. Please rise for the jury. The record will reflect that the jury is out of the courtroom and into the jury room. Mr. Jean.
Thank you, Your Honor. At this point, we would move for a directed verdict on the sole count of aggravated domestic violence. As the court is aware, part of the statute does require that there be a serious or aggravated injury. I think given the testimony that has been presented today, it is very clear that there was no serious or aggravated injury. While Ms. Crawford was in the hospital, the testimony was very clear that she had no lasting injury that had any serious impairment on any bodily function. She also indicated herself that she didn't believe that the injuries were serious. It's very clear within the context of the jury instructions that an aggravated injury requires immediate medical treatment or causes disfigurement, impairment of health, or impairment of a part of the body. She indicated that she had pain. She was given pain medication for it. She indicated she had no follow-up from any of this. She continued on with her life. I would argue that the fact that there's a requirement that it is for immediate medical treatment, or the other three, that we do not have that here. Because we don't have that, it is impossible for the people to sustain their burden on this particular charge. And so we would ask for a directed verdict on that basis.
Response?
Thank you, Your Honor. Obviously, there's a lot of evidence that's been put in on this particular issue. I think it was clear, really, from the testimony of both witnesses that she needed to go to the hospital to be treated. She clearly said that she wouldn't have been able to go to sleep. She was suffering from some pretty significant pain. And when she went to the hospital, the doctors obviously felt it was appropriate to put an IV in her and give her some fairly substantial pain medication. She was diagnosed with, according to Ms. Crawford, she was diagnosed with bruised ribs as well as a concussion. I think both of those things certainly require immediate medical attention. I think it's important also to look that that's all that's required. A serious or aggravating injury requires immediate medical attention. The next word is or disfigurement, impairment of health, or impairment of the part of the body. So all that's required is the immediate medical attention, which she did seek, she needed to seek, and obviously she went to the hospital. That's where she was interviewed. Thank you.
All right, thank you. The testimony placed in the record is just from the two witnesses, Ms. Victim Victoria Crawford and Officer Haggard. The victim did testify that she was diagnosed with a concussion, that she was given pain medications. Although I believe that this is an issue of the weight of what the jury makes the determination of fact, whether it's suffice. There is some fact for them to make a determination on. If there were none, and she had not gone to seek medical treatment, might grant the motion, but in this case, though it is certain going to be the argument of the defense that it doesn't meet that standard, it's an issue of weight for the fact finder to determine and not for the court to be a super juror and make his own decision. So I'm going to deny the motion for summary disposition, let the jury make the determination as to whether or not the testimony from Ms. Crawford and Officer Haggard and the video was sufficient enough for them to determine if there was an aggravated injury. You need a moment before we bring the jury back in to make a decision regarding any witnesses?
No, Your Honor.
Are you planning at this time to
No.
place any witnesses on? Where are we at as far as closing statements, realizing I don't want to rush anyone, want to make sure you've collected your thoughts, but also trying to be mindful of trying to get the case concluded today?
I'm ready if Mr. Dean is.
I am as well.
Okay, so we can bring the jury and go right to the closing
Your
arguments.
Honor, if I could, obviously Mr. Hager's been up now for I don't even know how many hours. It's a bit unusual to dismiss him before the verdict. If you'd like to go, I think that would be appropriate if the court's okay with it.
Any objection?
No, Your Honor, I certainly
What I
understand.
think I will do is bring the jury in and explain that
Sure.
that have you close your case. And then at that point in time, there'll be no reason for have a rebuttal witness and say the officer can be excused so you can get some sleep, because I don't know if you have to be on duty again tonight.
He does.
Okay, well then, there we go.
Yeah.
Let's bring the jury back in, please.
Thank you.
All right. Jury's back in the courtroom. Everyone, please be seated. At this time, ladies and gentlemen, the people have rested. The defense has no burden whatsoever, but they may place a case on. Mr. Jean, at this point in time, what is the defendant's plans?
No witnesses, Your Honor.
So the defense rests?
Yes.
All right. The next two phases of the trial are closing arguments and then final instructions. Officer Hager testified that he was on duty last night and testified today, and he's apparently got to be back on duty tonight. And so the attorneys have determined there's no more reason for Officer Hager to be here. Typically, the officers stay, but when they have to go back to duty, shift starts when, sir?
It's supposed to be 6:30, but it'll get pushed back
A little bit back.
because
We're gonna let the officer go back and get some rest. So I presume that there's no objection to that, Mr. Schminsky?
No, certainly
Any
not.
objection, Mr. Jean?
Certainly not, Your Honor.
So thank you, officer.
thank you, Your Honor.
And so what we're going to do is I'm going to have you turn the attention to Mr. Schwinsky once Officer Hager has an opportunity to leave. He's going to make his closing statements. Mr. Jean gets a chance to his closing statements, and then Mr. Schwinsky gets a second opportunity because he's got the burden of proof. We're going to take a quick break just to clean up the last of the instructions. The reason why is that we have no idea as to what type of evidence might get in or not get in. There's a couple of paragraphs I think that we have to take out because it just didn't happen. And so we got to clean those up. So you'll go back to the jury room. You'll come back to final instructions. Then you'll get the case. Mr. Schwinsky, are you ready?
I think I need Ms. McLaughlin to come in and turn the video back on.
Okay. You probably need the CD?
No, I'm just using a very simple PowerPoint presentation.
Okay. Yes. No, I think she should hear us. Katrina, can you hear us? I'd like you to come back in, please. Looking just like that. There she is. Mr. Jean.
Thank you, Your Honor. Good afternoon. So, sometimes you get cases that end up being really complicated, really long, and kind of drawn out, and they're sometimes pretty exciting. And then there's cases kind of like this where it's pretty short. I mean, we had testimony all done in about an hour, so sometimes it can feel like, oh my gosh, you're wasting my day. And there are two people that came and testified. Not a lot of questions are really being asked. But to be fair, this case is relatively straightforward. We don't need to delve into a whole lot of technical issues. That being said, one of the things that we did talk about this morning at board here that I asked you guys about was that whole idea of reasonable doubt. And I asked, do you have a problem where if you think, man, you know what? I think he probably did something, right? Something happened. I think he probably did it. But like that pill bottle, right? There's one thing in there, just one, that causes a reasonable doubt. If you could put those gut feelings aside and say, look, it doesn't meet the technical requirements here, so I have to find not guilty. I asked you if you guys could do that. You guys said, yeah, I can do that. That's what I'm going to be asking you to do. And that's what I am asking you to do. It's a very, very simple issue. Whether or not you believe the story about the assault occurring, I think there's absolutely reasonable doubt there on the basis that Ms. Crawford's story changed dramatically. So if we just start with that, we'll get on to, I think, kind of the glaring issue in a minute, but Mr. Schwinski says, well, it's been a year since this happened, memories fade, and they have a complicated relationship. So maybe that has an effect as to why she says what she says today versus what she says on the video. I would put to you, it doesn't make a difference because there's absolutely no reason for her to do that. None. So if you think about it, it's not as though she came today and said, well, he never did anything because she wants to protect him. If she had done something along those lines, it might make sense. Well, they have a complicated relationship, so she doesn't want anything to happen to him. She's just trying to protect him. She doesn't do that. Today she comes in and says, well, yeah, he assaulted me, but it didn't happen outside, it happened in the house. And she says, well, I told the officer says, well, it was on the porch when I got home, but that's not what happened. He was in his car. Those are things that there's absolutely no reason for her to lie about. None. So why say one thing then and then come in today and say something different? I put forth to you because, well, the whole thing could have been made up. Now, we'll move on from that because you have to make that determination if you believe that story or some version of it. Keeping in mind that if there is a doubt there, a reasonable doubt as to whether that's true, that should be reason enough for you to find John Curry not guilty. Not because not because you like the idea of it, but because that's part of what we're trying to accomplish today. It has to be a burden the prosecution meets. There absolutely is a reason for that. For the same exact reason why you would not want to be accused of something and have kind of like a social media trial. Well, I just don't like it. I don't like how it sounds. Kind of feels like it's probably true, so therefore it is. We have a higher burden for a very good reason. I would agree with Mr. Schwinski. There is no real issue here regarding the dating relationship. I would agree. We don't need to talk about those things. The third, the biggest element in this case is, without a doubt, the concept of injury. This serious or aggravated injury. So there's a couple of things that I think are important. I mean, there's always charging decisions that a prosecutor can make. They decided to make this charging decision. This is what you are stuck with. Okay? These are the elements that you're stuck with on this crime. Frankly, if something else had occurred and something else could have been charged, that is on the prosecution to do. They need to make other charges if they believe there's something there to sustain those charges. It is not for you to say, well, you know, I think maybe there was an assault that occurred. I don't know how I feel about the injury, but I kind of feel like an assault occurred, so I'm going to find him guilty on it because of the assault. That's not an option for you. It's just not an option. It either has to be the aggravated assault or nothing. That can be a failing of the government here. That something else should have been done and it wasn't. What is an aggravated injury? The jury instruction is going to tell you something very specific when it comes to an aggravated injury. There's a disjunctiveness to this, meaning it doesn't have to be all of them. It could be one or combination, okay? But it says a serious or aggravated injury is a physical injury that, this is the important part, requires immediate medical treatment, or that causes disfigurement, impairment of health, or impairment of a part of the body. Now, I think it's pretty clear that there's no disfigurement here. Ms. Crawford testified as much. Impairment of health. She got some pain meds, she said, and that was it. No impairment of health. She walked away, lived her life just normal. No impairment of part of the body. She didn't have a broken arm. She didn't have anything else that sustained on her body that caused any impairment. Remember, it must cause impairment. So really, what we're dealing with, and Mr. Shawinski in his closing put up that only that one portion requires immediate medical treatment. That's what he highlighted to you. Requires immediate medical treatment. Now the argument has gone thus far, but unfortunately I don't get to come back up and rebut anything that Mr. Shawinski comes up with for the next portion of his rebuttal, but it requires immediate medical treatment. I think you could all probably come up with a lot of the different things that would land somebody in the hospital but don't require immediate medical treatment. I can tell you that I had a back surgery, had a lot of pain at one point. Went in, doctors had told me, well, can't do anything for you. You got to go see a specialist and you got to set up a surgery before you can do anything. There's pain, but it's not something that required immediate medical treatment. The question here is, were the injuries that she says she sustained, did they require immediate medical treatment? The answer is no. She says that she had bruising on her rib area, I think on her collarbone, and her arm. Well, ultimately, you can get a bruise from many, many things. I would assume you here today may have some bruising on your body as you sit here, but you don't need immediate medical treatment. What are things that would require immediate medical treatment? Broken arm, right? That requires immediate medical treatment. You're bleeding out somehow profusely. That would require immediate medical treatment. It needs to require it. Not just that she went to the hospital. It's not that she says, well, I was in a lot of pain, and so therefore I needed medical treatment. No. Requires it. Pain does not require immediate medical treatment. That is what we have to determine. So the other thing I think is really interesting about this particular issue is Crawford told you she didn't think her injuries were serious. She told you that. And Officer Hager said, well, in my report, I put apparent minor injury. That was what the officer put in his report, apparent minor injury. That third element cannot be met. It simply cannot be met. There is more than reasonable doubt as to whether or not it meets the definition. The injuries that she says she sustained meet that particular definition. Now, you might go back and you might say, as I indicated a little bit ago, you might not like it. You might not like the fact that you go back there and you think, you know, I think the assault happened. I don't want this guy to walk because I think he assaulted her. But unfortunately, that's not what you have in front of you. You might have been able to, but you don't. You have to make a determination as to every single element. That last element, particularly, it's not there. It's just not there because there is no serious injury that required medical treatment. Because of that, there is more than reasonable doubt. Think about the pill bottle. That's a whole lot of cyanide pills in that pill bottle. You're not going to take it. You can't convict Juwan Curry because there are too many things that say there's not enough proof here. So, what I ask you to do, because it's so vitally important that it's not just whether or not we kind of come to that right conclusion, because there's another thing at play here. This is you having the opportunity to make sure that you are holding our government toes to the fire. It's not saying, well, gee, I want to make sure I'm kind of doing the right thing. It's the government needs to do the right thing. The prosecutor needs to give you the right charge, if that's what it was. Your job here is to hold their feet to the fire as well. To say, if you couldn't prove this, why charge this? Why not charge something else? That's a failing. That's a failing, and you can correct that by finding him not guilty. It protects you too. It protects you too. By making sure that you don't have charges on fellow citizens that don't make sense. It might not feel good. You might not like it. But that is the right conclusion here. That is the correct conclusion here. I think it's the only conclusion that you can come to. So when you go back into deliberations, there's multiple things that can happen. If you guys don't agree, you get instructions on things like that as well. But what I like to tell people is this. If you have a belief, don't give up on that belief. That's actually going to be part of, there's some instructions that are kind of on topic on this, but don't give up that belief. Obviously talk amongst yourself and try to come to your logical conclusions here, but don't give up just because you want to go home. Stand your ground for what is right here. Don't give it up. I would tell you eventually you would get to go home. Might take a while, but eventually you would. So I would ask you again, while this might not be the case of the century, I still think that it is incredibly important, and I would ask that when you go back to deliberate, that you very carefully review those instructions as it relates to all of that evidence that you have heard, and render that correct, just verdict of not guilty. Thank you.
All right, Mr. Schwinsky has one more opportunity to argue.
Thank you. Well, I'm gonna give you a lot more credit. I don't think I'm not looking at 6 people who just want to go home. I could tell throughout the whole trial that you were paying attention and you want to get to the bottom of this, frankly. And that's what it should be. I'll hold my feet to the fire every day. That's what I do as a prosecutor. And I believe the charging decision was proper. I believe that it's proven beyond a reasonable doubt without question. Listen, I'm sure we've all been to the ER. Nobody wants to go to the ER. It's a miserable experience. You go to the ER because you need medical treatment. And it was clear based on what Ms. Crawford said, as well as the statement she made in the body cam, that she was in pain. She was visibly in pain during that statement. And she had a concussion. I think certainly that requires some medical treatment. We all know the consequences of that. Certainly if anyone's a professional football fan. As well as getting kicked in the ribs over and over again. All of those things require immediate medical treatment. She was at the hospital. She went to the ER on purpose. No one goes to the ER on purpose unless they need medical treatment, and she did. And that's clearly what Mr. Jean wants to focus you in on, that particular element. Not the assault, not the domestic relationship, just that element. And yes, every element needs to be satisfied, and it has been based on the testimony. So I would ask you to deliberate, take as much time as you need. I think very clearly when you review, when you talk about the testimony, when you take a look at the exhibits again, if you need to, you'll come to that conclusion. Yes, there was an assault. Yes, there's clearly a domestic relationship, and almost without a question, beyond a shadow of a doubt, which isn't the standard, by the way. But yes, there was very clearly injury that required immediate medical attention. I do want to talk about reasonable doubt for a second because I think it's important. I just used that phrase, beyond a shadow of a doubt. That's not the standard. The standard is beyond a reasonable doubt. I think sometimes people get hung up on this. So think about a scientific experiment, right? They do that thousands of times to try to come to that conclusion. A crime happens one time. One time. It doesn't happen 1,000 times. It happens one time. And that's why the standard is beyond a reasonable doubt, not beyond a shadow of a doubt. So take a look at all that evidence, as I said. Take your time in deliberations. I'm confident you'll come to the conclusion. And I'd ask you to come back with a guilty verdict. Thank you.
All right, ladies and gentlemen, what we'll do is have you retire briefly to the jury room. We're going to make sure we got the final instructions ready, and then we'll have you back in for final instructions, then you'll be delivered. Please rise for the jury. The record will reflect that the jury is in the jury room. You may be seated. Mr. Schwinski, is there anything before we start talking about jury instructions that you need to place on the record?
Not for me, other than if the jury does want to review the video, obviously it'll have to be done if they've already been instructed on it.
All right. Mr. Jean, before we get to the instructions.
Nothing.
Okay. There were a couple of things that I made notes. There were a few format questions on pages 6 and 9 regarding the pronouns that I've had fixed. But from my review of the instructions, it would appear now that since Mr. Curry decided not to testify, we should add instruction 3.3 talking about the defendant's right to not testify. I presume that you would request that, Mr. Jean.
I would, yes.
No objection?
No objection.
Okay. Also, there was on page 15, it was highlighted yellow. Again, this is trying to determine what may or may not come in. I see instruction 4.1 is grayed, probably yellowed on the actual, but grayed on the document I have. I don't think that applies here, but maybe it does.
I agree.
I don't think that it does.
Okay,
Yeah.
so 4.1 will be taken. Are there any instructions other than 3.3 that either of you wish to have added?
I think, not added. I would want one removed.
Which one would you like removed?
7.04, the alibi.
Yes, and you would agree with that?
I would.
All right, so 7.04, lack of presence or alibi. Yeah, it didn't come up actually. So 704, I did ask Katrina to take that one out already. Any others that need to be added or removed, Mr. Schwinsky?
No, I don't see anything. Right?
Added or removed, Mr. Jean?
I don't think 5.03 came up, but I also don't think that it's harmful to have it in anyway. Witness who has been interviewed by a lawyer.
There was some discussion of going over the police report, so I guess it could be inferred.
That's fine.
Leaving it in is fine by me.
There was one question that one of the jurors, I believe it was juror number 6, that raised his hand and asked for a section to be played over again in the video.
Yeah.
And in that section, it says this has happened before. So I wonder if instruction 4.11 would be something that should be placed in, and I can read that.
I wouldn't have an issue with that.
That's fine, and it was my intent to exclude that as best I could. That's why we ended where it was. Obviously, it's very difficult
They
to
have
hear.
very keen ears and picked up
Yes.
on that fact. So 4.11 says evidence of other offenses. And so the standard instruction, I think we probably could tailor that
That's fine.
in such a way to add in to make sure that they don't use that for any purposes that are inappropriate. Any other instructions, Mr. Jean, that we should exclude or include?
I think on page 14, for 3.11, paragraph 6, I don't think we need to include paragraph 6. That would be for lesser included.
It appears to make sense to me.
That's fine. I was not requesting lesser included instruction.
Okay. And neither of you are. So we take 6 out. Would there be any objection, because these are standard jury instructions, any objection to taking 6 out and make 7 number 6? Otherwise, there'll be some
Right.
concerns as to what they're missing.
No, that would be fine, Your Honor.
Okay, so we'll make 7. Katrina, are you listening in on, since I'll probably be asking you to help me with this?
Doing it as we speak.
She's doing it as we speak. Doesn't surprise me one bit. All right. All right, so we'll make 6, 7. Is there any other spots in there that talk about a lesser included offense? Neither, and I presume that's true, Mr. Schwinsky, you're not asking for a lesser included, and neither are you, Mr. G.
Correct.
No, I'm not. I made the decision not to do that. Your Honor.
Okay. So I don't think there are any other changes. Do you want one moment of what I think we'll do is we'll go off the record now. I'll have Katrina print those changes. Sounds like she's made the changes already. Hand you both a fresh copy. We'll give about 10 minutes to take a look at it just to make sure none of us have missed anything. And use the restroom or whatever we need to do. All right. So if we could, Katrina, go off the record. I'll go off the record here as well. And then if you would print out 3 copies for the 3 of us. And then once we get the thumbs up, we'll print the copies for the jurors. Did you get my